just want to say welcome and thank you for joining us for our initial episode of What's on Tap. So a lot of people have asked me over the last few weeks, what is this What's on Tap concept all about? Really, it's about three things. It's about number one, it's about a lot of good questions that our clients have been asking us over the past couple of years. And what we noticed, there's a theme to those questions, and what we decided to do was kind of take those questions together and put together this 5-part series so we could provide those responses to the clients. Second, it's about doing something different. We wanted to do something other than the normal PowerPoint where you've got a PowerPoint presentation and a head in the background. So we're trying to be a little bit unique. Hope you guys like it. We know it's a little bit different, but we're going to see how it works out. And then finally, it's about kind of being something different. One thing we love about Weltman is they give us the opportunity to do something that is a little bit unique, a little bit different. I know a lot of you folks out there have been involved with and seen the Coffee with Casey, which, by the way, I highly recommend. Casey Hicks out of our Illinois office. So we're kind of stealing Casey's concept and doing something that means something to us and something that we enjoy, and that's the beer. So what we're doing is we're going to talk about different beers on each episode, and they're going to be local. They're going to be Philadelphia, Pennsylvania, New Jersey beers, and we're hoping that maybe you'll try these local breweries out and see if you like them. So with that, I want to talk about a little something related to this interactive concept. First of all, send us your questions. We can't guarantee that we're going to get to all the questions today, but we can guarantee you that we're going to respond to each and every one after the episode. So send us those questions, and we'll do our best to get as many on as we can today. Also, when this episode ends, there's going to be a PowerPoint that's going to be given out. So it'll have all the information we shared here, so something you can take with you and you can enjoy it. And finally, we'd ask, there's going to be a survey. Please complete that survey, because that survey will give us some ideas of, hey, where are we messing up? Where's it going well? Do I have to get rid of Cam? Do I have to throw him off the stage? We'll figure those things out, and you guys are the ones who are going to decide that. So with that, let me introduce everybody. First, I got Scott Best. Scott is our Jersey expert. Anything related to New Jersey law, Scott is the guy. He's out of our Philadelphia office, but when it comes to Jersey, Scott knows it all. Next to Scott is Cam Deane. Cam is our bankruptcy guru. If there's anything you need about bankruptcy, Cam is the guy who can answer the questions. In addition, he's got great knowledge related to Pennsylvania and New Jersey practice. Myself, I'm Mike Dougherty. I'm just along for the ride, listening to these guys give you some great information. So with that, let's kick it off. Cam, what's our first beer? What do we got going on here?
Thank you, Mike. The beer I wanted to talk about today is one called Broken Heels out of a brewery called New Trail Brewing, which is out of Williamsport, Pennsylvania. It's a brewery that makes a variety of beers, all of which are great beers to have. And Broken Heels, a hazy IPA, is one of my favorites. They have a tap house up in Williamsport, Pennsylvania that's always worth a visit if you're in the area. But if you can't make it there, I highly recommend trying Broken Heels Hazy IPA.
Oh, great. So for those out there, Broken Heels is our beer of the day. With that, so what this is all about. So our first topic is going to be replevins, repossessions, and repair shop liens. So we're going to talk about all three of these concepts. Everyone in this panel's got a little bit of knowledge related to each one of them. So Scott, why don't you kick us off?
So the question that most frequently comes up for us is someone defaults on, we'll examine this from the position of a car loan, which is what we most frequently see, is someone defaults on their loan. How do we tried to get the car back, what do we do? And that process is called, you can seek action through the court through a process called a replevin. It's the same idea in PA and New Jersey. Through that, you seek the court to issue an order saying, we have the right to go get the car on behalf of our client. It involves the sheriff going out and serving the papers to the borrower. Sometimes, if necessary, if the car is held in a repair shop, you serve it on them as well. And then you, hopefully, through that process, get your vehicle back, and then you're able to dispose of it. One question that we get asked frequently as well is, what do we need to send you? If we decide to go down the route of a replevin, what do we need to send you in order to get the process started? We typically say you need to get us, at minimum, the contract. If you have the application for the loan, that's great. The title for the vehicle is also, while not necessary, very much appreciated. It helps establish your right to recover the vehicle from with the court.
Well, Scott, I didn't mean to cut you off there. So in addition to that information, do they have the right to also try and recover the amount due on the loan? Or can in Jersey, you just have to seek possession of the vehicle? Can we do both in Jersey?
You can do both. You can either seek to just recover the vehicle, you can seek to recover the vehicle and money, or in the unusual circumstance, but it does happen where you can't find the vehicle or you think the vehicle is not worth anything anymore due to the condition it's in. You can, at that point, just seek to recover the money due from the individual.
Well, with Reg F out there now, when you're trying to recover the money, what do our clients need to present to us? What they need to provide so that we can seek that monetary judgment as well? What should they be sending?
They should be sending, if they have formal account statements, some lenders do have formal account statements where they say this is the amount that's due. Other times they just need to send us a payment history, something to support how we got from, say there's $24,500 left on the loan. Where did that number come from? How were payments previously applied? You just need a document that certainly supports the amount you are seeking.
Okay.
If you don't have that, a lot of courts, you can't prove the balance you're seeking.
That makes sense.
So once you make the decision to send the matter to us for replevin, you've tried self-help, which is allowed in both Pennsylvania and New Jersey. It's called self-help recovery, where that's the traditional method of sending out a recovery or a repo agent, try to find the car. If they find that they can't find it, it's in a garage, it's behind a number of other vehicles, or the individual is just not cooperative, then you need to go to the court and say, we need an order telling you to turn this car over to the bank or credit union.
So now what do you see in New Jersey as far as, I know there's, each county is the sheriff, some more aggressive, some less aggressive. What are you seeing as far as the sheriffs getting out there to try and find our vehicles?
Yeah, it's always county specific, and in some places, individual sheriff, deputy within the department. Some are very thorough. Some go out. Generally, they're there to try to help you as much as they can. But you do see differences department to department in what they need to proceed. The documents, at least in New Jersey, are all supposed to be uniform. But we found that some counties want an original of a certain document. Other counties will proceed with a scanned copy with the necessary signatures and everything. But some want the original, some want the scanned, and they're fine to proceed with either one.
Now, what's the timeline in New Jersey? So I'm a client, I'm sending over that replevin to you. When can I expect to get that judgment, get my vehicle? What's my expectation?
So in New Jersey, there's two different courses you can go down. One is supposed to be a more expedited process, but I've found that the timeline is roughly the same. It's usually 3 to 6 months, roughly, from the time you file the complaint to the time you get the order, because you have to allow for service, time for them to answer. So that roughly is going to get you in a 60-day window. You then have to file a motion with the court seeking them to say you have the right to recover this vehicle, and then you have to file a second document that is what the judge signs and seals, which you then send to the sheriff saying you were able to then go out and recover the vehicle.
Okay.
And at that point, you also provide the recovery agent information to the sheriff, and then they coordinate going out. At that point, we're out of it. Everything from then on is coordinated between the sheriff and the recovery agent. We'll then get a report back that says either they weren't able to serve the writ and they went there, no one was there, they went there, where they thought the car would be isn't there, and then you kind of, from there, you try to do further skip work to try to locate where the vehicle might be. Once you get the vehicle, if you do get the vehicle, there are notices that have to be sent advising the consumer that we have your vehicle, these are your rights, this is when we intend to dispose of the vehicle. Those also will differ by state, but generally they're the same idea of saying, we have your car, this is what you can do. If you don't come get it or don't come and pay for it, we're now going to dispose of the car and its contents and go from there.
Now, that's those statutory notices that each state is a little bit different with, right?
Yes, they're very different. New Jersey has one criteria. Pennsylvania, where you handle more things, have they're similar, but there might be slight difference to state.
Now, what I would recommend to our folks out there who signed up, 2 words, Stephanie Collier. Stephanie Collier is our person over at Weltman who handles all 50 states, and I can tell you she is an expert at knowing those notices. What you want to keep in mind, any mistakes on those notices, there's attorneys out there that are just trying to look for a typo. You didn't cross the proper T, you didn't put a dot on the I. So what I would recommend, folks, start looking at your notices, those statutory notices, and if you have any questions about that, reach out to us. We'll connect you with Stephanie.
And so that's the general process from a New Jersey perspective. I don't handle, while licensed in Pennsylvania, I don't directly handle very much in Pennsylvania. So, Mike, I gave you the general idea in New Jersey. How does it work in Pennsylvania? Is it similar? Is it different, or where might the differences be?
No, I would say in many ways it's very similar. So you talked about a timeline of 3 to 6 months. I would say in Pennsylvania that's a fair timeline as well. So for our clients out there, it's similar as well in the sense that you can do in Pennsylvania what's called a 1 or 2 count complaint. You've discussed it there as far as the 1 count is a possession only, and a 2 count is we also want the money. And as we talked about with Reg F, you want to make sure we get that documentation to plead that proper balance. So we always recommend the 2 count complaint because it gives you more options. Like we talked about, that 3 to 6 month period of time to get that judgment. Pennsylvania has a unique method called a writ of seizure. So what that writ of seizure is, you have the ability to actually get an order for a replevin in anywhere from 7 to 10 days. Now the twist to it is, in order to do so, you need to file a bond. And the bond has to be 2 times the value of the vehicle. So if you've got a $50,000 vehicle out there, you've got to post that bond for $100,000. So it can be significant, but realistically, the cost of those bonds are not too bad. And thinking about it, if you can get that vehicle in 7 to 10 days versus 3 to 6 months, there's a value to it. I mean, you guys have seen it, right? As far as used car prices right now, they're going through the roof. So the sooner you're able to get that vehicle, the more you're going to be able to recover when it comes time for selling that vehicle. So in addition to the writ of seizure, the next question becomes, okay, what if you got your judgment now in Pennsylvania? We're very similar to Jersey in the sense that each sheriff is going to be a little bit different. Some are very aggressive, some not so aggressive. And you basically sometimes you got to push them a little bit. So one of the things that we have an advantage with over at Weltman is we have great relationships with probably every sheriff in every county. So they know that we want them to go out, do all they can to get the vehicles, give us good information, because that's the big part, this is good information. Oftentimes the sheriff will come back, they'll find the vehicle, and they'll say, you know what, hey Mike, it's in that garage over there, or it's behind this fence. The sheriff's not able to go in and break open the garage or knock down the fence, but once he lets us know that, there's a method in Pennsylvania called a motion to break. So what we do is we file that motion, and we go to the court, say, hey court, we found the vehicle, we know where it's at. The sheriff told us. He says it's right there, we just can't get to it. So what the court will do, they'll issue an order, and they'll say, sheriff, you can go in there and you can break into that garage. You can open up that fence. And we've had great success for that. So basically what happens is you see a lot of these folks who are trying to hide those vehicles, and when they start seeing these type of orders coming from the court, we're getting a whole lot of traction on them, which is nice to see. Now, one of the issues that I think affects everybody out there, without question, and it's the one thing I get more calls about this particular topic than anything. So here's the situation. You know where your vehicle is. A tow shop or a repair shop is giving you a call. We got your vehicle. You owe us $1 billion to get it released because it's been sitting here for 30 days, and we're charging you $500 a day in storage. Cam, what do we do? How do we get the vehicle back?
Well, thanks, Mike. And yes, I'm sure for those auto lenders out there, everybody has dealt with that situation and received that type of phone call before. But the issue really is, what is proper notice when that issue arises? So the phone call generally is not sufficient notice, but that is the most important part of that whole process for everybody listening out there. So what I mean by that is the auto lender has an account that's in default. You determine that the location of the vehicle is an auto repair shop. Once that repair shop has sent you a written notice indicating they have possession of the vehicle, at that point, you're now on the hook for those storage fees.
Okay, and I don't mean to interrupt you. So what kind of notice, so by written, does that have to be certified in the mail? What should our folks expect? I mean, when does that clock start ticking in your mind?
The clock starts ticking once the notice is received, and it is a certified mail notice that you will receive from the auto shop. At that point in time, I mean, they can have the vehicle for 6 months prior to sending out that notice, and that's where the $1 billion in storage fees will arise. You're not on the hook to pay that $1 billion storage bill in order to recover the vehicle. You're only responsible to pay reasonable storage fees from the period of time that the notice was sent out to you and the date you're actually recovering the vehicle. Now, in addition to that, I mentioned the word reasonable storage fees. In some jurisdictions, whether it's Pennsylvania or New Jersey, there may be a cap. For example, Pennsylvania has an actual cap, hard cap of what storage fees can be charged on a daily basis for auto repair shops, but other counties, again, rely on the reasonable storage fee formula that a court would determine.
One argument I always hear from the tow shops, and it's the common sense argument in their mind. Possession is 9/10 the law. So meaning we got your vehicle, and Cam, you just told us about this notice provision, and that's all well and good. So I now call them up for my clients. Hey, you sent them notice on Monday. This is Tuesday. We'll pay you $50 in storage fees, release the vehicle after their laughter subsides to me. What can I do? Because at that point, they've got the vehicle. I mean, I can't forcibly get it out. What's my option? How do I get my client's car out of there?
Well, when I'm discussing this issue with clients, it's really a practical approach. Now, you both just discussed the process of a replevin action in Pennsylvania and New Jersey, and that would be the correct approach if you wanted to address this in the court system. You can file the replevin action, and your lien against the vehicle will in fact take priority over any storage lien against the vehicle by the auto repair shop, and that applies both in Pennsylvania and New Jersey. But there's a cost associated with that, and there's also a time value of money issue associated with that. So you can go through the process of filing the replevin action, get a court order that says you are entitled to possession of the vehicle, and then use that to actually take the vehicle from the shop without necessarily having to pay the storage fees. But you would incur a larger storage fee notice by doing that. Ultimately, you could be on the hook for those storage fees, and that replevin action may take several months to take place, as you guys have already filled us in on. So at that point, it may be beneficial to simply negotiate with the auto repair shop, and this is another practical consideration. Try to develop relationships with the shops that you deal with on a regular basis. Unfortunately, people will always default on their auto loans while it's in possession of an auto repair shop or tow yard or something along those lines. So it benefits you as a lender to build up and then maintain relationships. It's much easier to negotiate those storage fees with a shop you deal with on a regular basis than to try to go through the replevin process and essentially stiff them on the fees.
Well, let's talk that through. So the reality of it, right? So what you're saying is from a legal perspective, purely from a legal perspective, our clients aren't on the hook for $1 until they receive that notice. Is that fair to say?
That is correct, yes.
But now we have the practical perspective, right? So now tow company says, I'm just not releasing it, even though they know the notice provision, but they're saying, you know what, we have leverage because we have the vehicle. So what they're having to weigh our clients is there's a cost to us, right? They got to pay us.
Exactly.
There's a cost to the courts, right?
Yes.
So I guess when you factor those two things, and then you also mentioned as well the cost of time, right?
Of course, yeah, and with vehicles, I know it's a strange time now where used cars are worth more than they were when they were sold, but generally speaking, there's going to be a depreciation component to your auto value, so the sooner you can obtain possession, the better in terms of your ability to recover and satisfy the outstanding balance on your auto loan.
Well, now let's talk about something a little bit unique to that. So we know about the tow storage charges, that the notice provision there. What if a shop has done some repairs? Say an engine went out, they had to fix the engine, they had to put their time, money, and effort into it. Do I tell my client, hey, you're on the hook for that? What's my advice to them in that particular situation?
So in that instance, that will actually depend on if your loan or the location of the vehicle is in the state of Pennsylvania or New Jersey, the two states that I practice in. In Pennsylvania, the shop is actually entitled to recover the costs of actual repairs made, and that would be a lien that takes priority over your loan against the vehicle. Now, the same does not apply in New Jersey, but your lien would maintain a priority over the repair shop lien. But at the same time, those same practical considerations would apply for a New Jersey matter. In Pennsylvania, however, your steps there should be to seek documentation from the shop, proof of actual repairs being made, and that'll include things like estimates, receipts of parts, and any sort of labor documentation they can provide to show that the repairs were actually made. And that's all because they've added value to the vehicle. Because of that value added and returning the vehicle back to a a complete form, that creates a priority lien over your auto loan.
So basically what you're telling us is you want to make that repair shop prove it, right? Don't take them at their
Yeah.
word.
Don't take them at their word for it. Make them produce some evidence and documentation to actually justify that cost. But assuming they can comply with that request, then that does have to be satisfied in Pennsylvania.
Okay, great. I think at this point, I know we've been getting some questions coming in, so this is probably a good time. Let's answer some of our team's questions that came in. What do we got here? Okay, we got a question concerning, can I file replevin against a repair shop or tow company that has my car? Let me take this one real quick. This is an easy one, absolutely. So in Pennsylvania and Jersey, correct me if I'm wrong, Scott, you can file that replevin against that tow company or that repair company, and we highly recommend it. We recommend it because I would not waste a lot of time negotiating, right? I would probably do 2-3 days negotiating tops. You know where they're going to be with it. And if they're not moving, you want to get that filed as soon as possible. You have the writ of seizure method in Pennsylvania to use. Jersey has some expedited processes as well. right,
Yes,
Scott?
yes, in New Jersey, I would definitely recommend it, especially because of the priority issue that Cam discussed, that the repair shop does not have any right to keep your vehicle, even if there's money due on repairs and storage. We frequently mention that in our complaints when we name a repair shop, that here's the statute that says you don't have the right to charge us for that. And there is an expedited process in New Jersey. It's called a verified complaint. It's you attach the writ and everything right to the complaint. The judge then gives a date that they have to respond by. It dictates types of service you can serve by mail, regular mail. It does speed it up, but you are then on the judge's timeline. It theoretically speeds it up, but if the judge's timeline can be very short, and if you don't get service, the case then kind of lingers for longer than it should, because you're waiting on the court to issue the next date that you have to, the defendant would have to respond by. So it is good because if you get service quickly, you can get the writ a lot quicker, and then you can get it out to the sheriff. But if there's an issue with service, it sometimes can get more bogged down than the traditional method. And also, when you do that method, you can't seek the monetary damages in the same way because of the expedited process. It doesn't go through the normal cycle of a complaint, answer, default, everything that is associated with a normal complaint seeking a balance due. That process isn't there. It's just there for an expedited recovery of the vehicle. It says they didn't pay, we have the right to recover the vehicle. Everything is just done in this much larger writ document, which can work if you can get service within the timeline that the court provides. But if you miss that window, it then kind of gets stuck in a cycle where it's kind of in no man's land unless you're continually refiling for the writ.
So it seems like the answer to the question is yes, make sure you get that filed. And I'm being waved down to more questions. It looks like, wow, they're coming in pretty good. What do we got here now? Okay, and this looks like something I think you should be handling. So how do you handle recovery when the government, such as local police or DEA, has seized the customer's vehicle? That's interesting.
So that's a great question. And actually, I have 3 recent examples that cover 3 levels of government intervention on this topic. So a quick example is in Philadelphia, we have something called the Philadelphia Parking Authority. And most major metropolitan areas are going to have something similar. It's essentially meter maids who ticket vehicles and eventually boot vehicles, and after enough time passes without payment on those tickets, will take possession of the vehicle and keep it at a tow lot. There's a statute or ordinance, I should say, in Philadelphia that says they're entitled to recover all of the outstanding fines, fees, and costs associated with the tow, booting, and illegal parking of that vehicle before a lien holder can take possession of it. So that is something that applies specific to Philadelphia. You would need to check your local city ordinances to see if a similar statute applies. If there is nothing that says they are entitled to that before you can have possession, then your lien will have priority. Your loan will have priority over their lien. Okay. Now, the next level up would be state court, and usually this comes in a criminal proceeding. The example I had recently was a case or a car that was reported stolen in the state of Michigan, was then found by the Pennsylvania State Police and then taken as evidence for a criminal proceeding against the individual that it was in possession of the vehicle at the time. So in that instance, what happened is we had to file a petition to recover the property, the vehicle itself, once it was no longer necessary as evidence in the criminal proceeding. So if your vehicle has been taken by the state police in Pennsylvania or similar in New Jersey, what you would need to do is reach out to that agency to find out what the status is of the vehicle and at what point they're willing to release it, because depending on the circumstance, it may just be getting used as evidence. Once it's no longer needed as evidence, then you can recover the vehicle and go through a typical disposition process. Now, the highest level that you might potentially deal with would be the federal government. And a recent case I had where an individual's vehicle was seized as part of a drug enforcement agency investigation. That one is a little bit different because in that case, the DEA is actually seeking civil forfeiture for the purpose of paying fines.
What do you
and
do?
fees.
Do we know?
Yes. So in that situation, you have to actually file a claim for recovery of the vehicle if the DEA liquidates it on their own through the forfeiture process, as well as a petition for mitigation. You want to file both of those documents, and it's something you will actually do on the DEA's website, and then the U.S. Attorney's Office will reach out to you or your attorney and fill you in on the status of the criminal proceeding, because at that point they're seeking what's called a judicial forfeiture. They need to get a federal court order that says the government's entitled to possession and liquidation of the vehicle, but it would be subject to your lien holder claim.
Well, I see we do have a lot more questions, but realistically, I think this might be a good time to stop. Folks out there, we know you submitted a lot more questions. We 100% will get to each and every one of them. We'll get you an answer within 24 hours for whatever you need. I just wanted to take this time now to kind of thank everyone for being here today. Thank you guys for signing in. As indicated, you'll get the PowerPoint at the end of the presentation. Please also get to that survey, fill that out. Also, by signing up, you have the ability to maybe win some of this really nice What's on Tap swag. One of these could be yours. You never know, but make sure you sign up so you have an opportunity to do that. With that in mind, what I have here, I want to talk to you a little bit about when the next one's coming up. Our next episode, November the 16th. And November the 16th, let me tell you what we got coming for you. The topic will be hailing responses to garnishments and levies, the do's and don'ts to make sure you're protected. Going to be a good topic. I think you're going to enjoy it. So I guess the only proper way to end this now is an Irish goodbye, right? What is it? Sláinte.